Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Unpaid seller's right of stoppage in transit. The right of stoppage of goods in transit, which is an extension of right of lien, arises only on the insolvency of buyer when the goods are still in transit. The unpaid seller can ask the carrier not to carry the goods if he remained unpaid. He may resume the possession of goods and retain the same until payment by taking actual possession of the goods or by giving a notice of his claim to the carrier or other bailee or principal in whose possession the goods are. No contract can be rescinded by mere exercise by an unpaid seller if his right of lien or stoppage in transit. Duration of transit. Goods are deemed to be in transit from the time when they are delivered to a carrier or other bailee for the purpose of transmission to the buyer until the buyer or his agent takes delivery of them. Even where the goods are rejected by the buyer and the carrier or other bailee continues in possession of them and the seller has refused to receive them back, the goods are still considered to be in transit. Termination of transit of goods. The transit of goods is deemed to have come to an end and the seller cannot exercise his right of stoppage when the buyer or his agent takes delivery of goods. The transit of goods also come to an end when the carrier acknowledges to the buyer that he holds the goods on his behalf. The transit comes to an end. When the carrier wrongfully refuses to deliver the goods to the buyer, the transit comes to an end. When part delivery has been made to the buyer, transit will end for the remainder of the goods which are yet in the course of transit. Whereas if part delivery is made with an intention of delivering the whole of the goods cannot be stopped in transit. When the goods have arrived at their destination but the buyer does not take delivery and requests the carrier to carry the goods to some further destination, the transit comes to an end. However, if the buyer rejects in taking delivery of goods and the carrier continues to possess them, the transit is not deemed to come to an end. Exercising the right of stoppage in transit. The unpaid seller may exercise the right of stoppage in transit by actually taking possession of the goods or by giving notice of claim to the carrier or other bailee who are in possession of the goods to his principal or carrier. Notice to principal. The notice to the principal must be given at such time and in such circumstances that the principal, by reasonable diligence, may communicate to its servant or agent in time to prevent a delivery to the buyer. Notice to carrier. But if the notice is given by the seller to the carrier or other bailee in possession of the goods, the carrier must redeliver the goods to or according to the direction of the seller, the expense of which to be borne by the seller. If the carrier, in spite of getting proper notice from the seller to stop the goods in transit, delivers them to the buyer or refuses to deliver them to the seller, he is liable to the seller for wrongful appropriation of goods. But if after completion of transit the carrier wrongfully returns the goods to the seller, he is liable to the buyer for such conversion. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.